you very much. If you're following the Supreme Court arguments over health care, you may feel as though you've fallen down the rabbit hole from Alice in Wonderland. Is the health care law equal to the sum of its parts, or do those parts have separate lives and separate meanings? And when is a tax not a tax? Well, here to help us sort it all out is Gail Sullivan, staff writer for CQ Weekly. She wrote a recent cover story about the health care hearings. Thanks for coming in. Good to see you.
My pleasure. Good to see you.
Interesting day yesterday, and what everyone's talking about is the questions that the justices were asking, the statements that they were making, which, you know, we all do this. We play this game. You try to read what they're saying and figure out, oh, well, here's how they're going to decide. It's a dangerous game, but yesterday there did seem to be some indication making it look like they might strike this thing down. What was your impression?
Well, I think you have to remember, in a case of such great significance in this very, polarized time, that the justices aren't going to throw softballs. They're asking difficult questions because this is a really important case, and they're going to do that whether they're inclined to uphold the law or strike it down. I think that Ginsburg and Breyer, their questions indicate that they're maybe more inclined to uphold the law, but the rest of them, it's really hard to predict. I think you have to be careful about predicting the outcome just based on the questions they're asking, because they are going to ask tough questions. And I think that the government's in a very difficult position having to articulate a limiting principle here, whereas the challengers have a little bit of an easier time, bringing forth the parade of horribles of what could happen if they do uphold the law.
Mm-hmm. How about Justice Kennedy? People are watching him very closely, his line of questioning and the like. What do you think about that?
Well, he kept reiterating that he's concerned about the relationship between the federal government and the individual. Kennedy is known to be very concerned about federalism, and he seemed to be pressing the Solicitor General, Verrilli, to articulate a limiting principle. If he is inclined to uphold this law, he wants to know, where does it stop? If I uphold this law, then what else can Congress do? He wants to make sure that he's not just opening the door for unlimited federal power.
Today they're going to talk about severability, meaning that if they strike down the mandate part of it, can the rest of the law stand, or
right.
Are the two linked together, and if one goes, the rest has to go?
Right, and there's basically three ways they can do this. The challengers, those challenging the law, would like the entire law to fail. In their view, every provision of this law is inextricably tied to the individual mandate. But the government counters that, there's some provisions of the law that are already in effect, whereas the mandate doesn't go into effect until 2014. So obviously not every provision is inextricably tied. If the government gets their way, they would like two other provisions of the law to strike to fall with the mandate. That's the guaranteed issue and community rating provisions, which require insurance companies to provide affordable coverage to everybody, regardless of pre-existing conditions. Mm-hmm. And the government says, well, those only work if you have the mandate, because the mandate brings healthy people into the insurance pool and keeps costs down. And there's also a third way that the court could go. And this position is being advocated by an attorney appointed by the court, H. Bartow Farr III, and that is to allow the entire rest of the law to stand if the government strikes down the mandate.
Okay, gotcha. All right. Now, it's very complicated. It really is very complicated. Let me ask you about this, the tax thing. Yesterday there was the talk about is the penalty that people might face, is that a tax or is it not a tax? Now, the government seems to be saying on the one hand, well, it's not a tax, it's a penalty, but on the other hand, they make the argument that, and I want to make sure I'm saying this correctly, this part of the law has to be implemented before it can be struck down, which seems to indicate that it's a tax. Are they arguing both sides of the fence here?
Well, kind of. The government's walking a fine line here, because on the one hand, they do cite their taxing power as a source of authority to enact the individual mandate. Mm-hmm. But on the other hand, you have to remember that tax for purposes of the IRS code means one thing, and tax means something else in other circumstances. So on Monday, the argument was about whether or not this tax law, the Anti-Injunction Act, requires the court to postpone a decision on the mandate. And if the penalty provision, the penalty I'm referring to is what people would pay in 2015 if they do not have insurance coverage in 2014, as required by the mandate. Is that a penalty or is that a tax?
Right.
And it's difficult because tax is not defined in the Anti-Injunction Act. So a lot of the discussion in the court on Monday was what is tax?
All right. I got to say, you have this down. You really.
Thank you.
I mean, it is a complicated issue. I think that's one of the reasons they have 3 days of arguments about all of this. So it bears watching. Gail Sullivan is a staff writer with CQ. Thank you very much for coming in.
You're very welcome. It's my pleasure.
Yeah, come back sometime.